applies, can I just draw your attention to the authority that I was trying to find?
That would be most helpful.
In fact, it was VW, which is in the bundle, so apologies for the scrambling around.
Tab number?
It's at tab 16, and the relevant paragraph is 5.
Is
Paragraph 5. The part I rely on is where the judge notes that there's a bright luminous line between characteristically right where writing.
oh right, we've been to this already.
Yeah. I think you've been taken to the head note, but I just thought it might be helpful to see it in
No,
the
that is most helpful.
That's the passage.
Excellent, thank you very much. So you're not going to need to send us any further citations. That's very helpful, thank you. Yes, reply.
Thank you. I mean, that in fact is a good place to start is with that case. I'm not going to ask you to look at it in any detail, but it's just in relation to the suggestion that if a procedural issue is to be taken with anything that happened in the first tier tribunal, that evidence in the form of witness statements needs to be provided. I mean, from what I understood to be, the Secretary of State to be suggesting, I would say is completely incompatible with the overriding objective of dealing with cases justly and fairly in the tribunal. And my understanding of the suggestion is that if, in a case such as this, some complaint about how things went in the first tier tribunal arises, the advocate is required to draft a witness statement and then cease to act as an advocate, because she would then be in the position of being an advocate having to give evidence. And I mean, in the circumstances of this case, I mean, Masdiri was representing the appellant pro bono in the first tier tribunal and in the upper tribunal. If she was required to resile from the case, the sponsor would be left having to find another pro bono representative to take over his case. And if the hypothesis is that Masdiri would need to come to the tribunal to give evidence, she would need to be taking another day out of remunerated practice to come along to do that. I mean, I would say that that is simply unworkable and a recipe for sort of injustice. I mean, it's clear that there may be situations that arise, and one sees some of them in the cases, that a contentious issue about what happened in the appeal below arises, and so the advocate from below could not properly carry on because she would have to give evidence. But I would say that in the usual run of cases, that the advocate would set out the allegation in the grounds of appeal, which is what happened in this case, or in a witness statement, that would go to the upper tribunal and to the Home Office. And the Secretary of State would have the opportunity, by way of a Rule 24 response, that's Rule 24 of the Upper Tribunal Procedure Rules, to state what the Secretary of State's position is in relation to whatever is alleged to have happened in the first tier tribunal. And if the Secretary of State does not take the opportunity in a Rule 24 notice to set out his contrasting version of events, or the fact that he does not accept the advocate's version, then it should be taken, I would say, that the upper tribunal should take the advocate's assertions, whether in the grounds of appeal or her evidence in the witness statement, as unchallenged and proceed on that basis. I would say essentially...
Upper Tribunal procedure rules in the bundle.
I'm sorry, my lord, they're not in the bundle.
Perhaps we could be provided with them. Okay.
Yes, certainly. And I'll also send, if I may, the first tier procedure rule dealing with the overriding objective, just to set out.
Yes, because it's a statutory, it's not the CPR overriding objective that applies. It has to be found in there.
Yes.
Yeah, just following up on that, you draw attention to what you say is the normal procedure, and in this case we were provided with the grounds of appeal to the upper tribunal that were filed on behalf of your clients when seeking permission to appeal, and so we see that ground 2 was that the upper tribe. Sorry, that's to this court. I apologise. So what I'm actually looking for is the relevant ground on the first appeal.
Page 28.
My lord, at page 42.
The ground is at 45, if that helps.
you.
So, paragraph 14 says in terms, the central reason for refusal relied on by the judge was never put to the appellant. So if you're right as to the procedure, then that complied with that stage. But you referred to a Rule 24 notice from the Secretary of State. Was there a document of that nature in this case?
No, there was no Rule 24 response.
Right.
And the case that my learned friend has just referred you to, the BW case, I don't ask you to look, it's Mr. Justice McCluskey talks about the Rule 24 response at paragraph 5, Roman 5, as being, it says, in every Rule 24 response, care must be taken to set out the respondent's position in relation to a witness statement of this kind. That's a statement dealing with the procedure. Thus, if the contents of the statement are undisputed, this should be simply stated.
Alternatively, any controversy regarding the contents must be highlighted.
Yes, my lord. So that's what I'd like to say about the procedure. Going back to the beginning of my learned friend's submissions, on the point of EU law about dependency, the reason that I raised that was to show that the EU law, was to make the point that EU law was not a knockout blow. There was no principle of EU law which meant that the arrangements that the sponsors would say existed, that those could not establish dependency in EU law. And I would say that
that's a legal argument which isn't before us, is it? I understand the point you're making, but as I observed to Mr. Skinner, these legal questions are debatable, but they all depend on a prior finding of fact.
yes, exactly. I would accept that entirely. And so my reason for having raised it was to show that this, as matters currently stand, there's no EU law knockout blow which entitled the Upper Tribunal to say, there's no evidence that he could have produced that would enable him to establish dependency. So I don't intend to say any more about, or want to say any more about EU dependency than that. The Secretary of State accepts that Surrendran Guideline number 5 was not followed in this case. And I would say that that should be an end really to the argument. I mean, I accept that it does not automatically follow that if Surrendran number 5 applies, then there was procedural fairness. But I would say it would need to be an exceptional case for Surrendran Guideline number 5 to be applicable and for there not to be procedural fairness. And I would say that this is simply not one of those exceptional cases. As I understood the approach being taken by the Secretary of State, I mean, the approach is to say that the burden of proof on every issue is upon the appellant. The appellant knows the issues that he has to prove, and in every immigration or asylum case, the appellant knows the issues they have to prove. They just have to look at the EEA regulations or the Refugee Convention, the Human Rights Convention, that tells them. So the burden is on them. They know the issues, and therefore there is nothing really that they can properly be required to have put to them. I mean, it was being suggested, as I understood the Secretary of State's case, that it would be an unusual case rather than the general run of cases where a point needs to be put to the appellant. The appellant needs to be given notice of what may defeat his or her case if it is not addressed. And I mean, my submission would be that it is in the general rule should be that if there is a point that would potentially defeat an appellant's case, and it is not a point which has been identified in the refusal letter, the decision being appealed against, then it is a point which needs to be put to the appellant either by way of cross-examination or, in a case such as this, by the judge identifying what her concern with the case was. A concern which, if not addressed, as in this case, would lead to the defeat of the case. I think that's all that I'd want to say by way of reply, unless there's anything that...
I don't think so. Thank you very much indeed.
Thank you, Lady.
Well, thank you all very much indeed. I might thank Derry who represented the sponsor both twice pro bono, and I suspect again today. The court is very grateful, as so many people would not be represented if large swathes of our professional bodies didn't appear in court pro bono. You won't be surprised at all to hear that we're going to reserve our judgment. I can't tell you precisely when that will be handed down, but I don't think it should be too long. It'll be sent in the normal way in draft, just for typographical and other factual infelicities, please, and not for re-argument of the case. I know you're all used to the newish embargo on the top of the draft, but can I just reinforce the importance of adhering to that? Any other matters I hope we'd be able to deal with in writing, and I hope you'll be able to agree in order in due course. Unless there's anything else that anyone thinks we need to deal with, I'll just thank you all very much indeed.
All rise if able.